Alright, so this week has honestly been one of the busiest weeks for U.S. immigration news in a long time. And if you're waiting on a green card, holding an H-1B, studying on an F-1 visa, or going through the asylum process, I promise you at least one of these updates directly touches your life. So stick with me till the end, because we're going through every single one of them. And trust me, you don't want to tune out halfway through this one. Let's kick things off with the biggest update. The August 2026 Visa Bulletin, issued by the U.S. State Department on July 20th, and this one brought some of the largest forward movement we've seen in family-sponsored categories all year. Now, if you've been following visa bulletins for a while, you know most months bring tiny, almost painful movement, a week here, a month there. This one was different. USCIS has confirmed that family-based applicants can keep using the dates for filing chart to figure out exactly when they're eligible to file their adjustment of status application, while employment-based categories, unfortunately, are still stuck relying on the more conservative final action dates chart, which means EB categories are only seeing minor advancements, mostly limited to EB3 Rest of World and EB1 China. So here's the part you really need to pay attention to. If your priority date is current under the filing chart, don't wait around, because you need to make sure USCIS actually receives your Form I-485 before the end of August. That deadline is real, and missing it could cost you months, maybe longer. And here's something a lot of people don't realize. Even if your case is current only under the filing dates and not the final action dates, filing early still comes with genuine practical benefits. Once your I-485 is pending, you become eligible to apply for work authorization, you can request advance parole so you're legally allowed to travel, and you get to stay in an authorized period of stay even if your current status is close to expiring. This is exactly the kind of window that closes fast, so if this applies to you or someone in your family, please don't sit on it. Now let's move to something that's going to affect a massive number of people. The H-1B world just got some big news. USCIS has officially confirmed that it received enough petitions to hit both the 65,000 regular H-1B cap and the 20,000 advanced degree exemption for fiscal year 2027, and multiple immigration law firms are now confirming the cap is fully reached and closed after just the initial selection round. What does that actually mean in plain English? No second lottery this year. If you weren't selected this round, that's it. You're waiting for FY2028 now. But here's what makes this year genuinely historic. And honestly, this is the part I find most interesting. This was the very first H-1B selection cycle ever run under the new wage-weighted selection system, a huge shift away from the pure random lottery that's defined this program for years. Under this new system, higher-wage job offers get a statistically better shot at being selected, which means the old pure luck of the draw era of H-1B selection is basically over. And going forward, salary is going to play a much bigger role in who actually gets picked. Quick pause here, because I really want to say this. If you're finding these breakdowns genuinely useful, do me a favor and hit that subscribe button right now, and turn on the notification bell while you're at it, because immigration policy in the U.S. right now is moving faster and changing more aggressively than it has in years, and I don't want you finding out about the next major shift a week too late. All right, let's keep going. Here's a change that's going to hit international students hard, and honestly, this one caught a lot of people off guard. The Department of Homeland Security has officially finalized a rule ending the long-standing duration of status admission policy for F-1 and J-1 visa holders, and this takes effect starting September 15, 2026. Multiple immigration law firms have already confirmed this shift, describing it as DHS eliminating duration of status for F, J, and I non-immigrants, and putting mandatory fixed admission periods in place, along with required extensions of stay going forward. Let me break down what that actually means for you if you're a student. For decades, international students could generally stay in the U.S. for as long as their academic program lasted, without a hard cutoff date hanging over their head. That entire system just changed. Now, students and exchange visitors will only be admitted until a fixed end date tied directly to their program, with a hard maximum stay of 4 years, plus a 30-day grace period tacked on at the very end. So if you're a student whose program might run a little long, or you're planning to extend your studies for any reason, you now need to actively plan ahead and file for an extension before that fixed period runs out. Because there's no more coasting on duration of status like there used to be. Now, here's some genuinely good news, and honestly, we don't get to say that often enough in immigration news, so let's slow down on this one. If you're anywhere in the asylum system, this one's for you. DHS has restored the rule requiring USCIS to decide first-time asylum work permit applications within 30 days. Let me give you the quick backstory on this, because it actually matters. That 30-day deadline had been stripped out earlier this year by an interim rule issued back in April, and that move triggered serious legal pushback, with nonprofits and labor groups filing challenges against it almost immediately. Well, DHS has now corrected course, and the fix applies retroactively all the way back to May 29, 2026, which means asylum applicants who got caught in that gap will once again benefit from faster processing on their very first employment authorization request. If you've been sitting there anxiously refreshing your case status, waiting on a work permit tied to an asylum claim, this is genuinely one to watch because it directly affects how quickly you can legally start working and supporting yourself in the U.S. But honestly, out of everything this week, the most explosive development isn't even a finalized rule. It's a bill, and it's barely a few days old. A brand new Senate bill was just introduced that could completely reshape the entire H-1B program as we know it. Republican Senator Tim Sheehy of Montana introduced what's called the End H-1B Abuse Act, and his argument is that the program should be fixing genuine labor shortages, not being used as a tool to replace qualified American workers with cheaper labor from abroad. In his own words, Sheehy has said the H-1B program was created to address workforce shortages for specialized, difficult-to-fill positions, not to displace hardworking Americans with cheaper foreign labor, and that this legislation is meant to restore the program to its original intent while closing the loopholes that allow abuse to happen in the first place. The bill itself, officially numbered S.5097, was introduced on July 24th and has already been referred to the Senate Judiciary Committee, with backing from groups like the Immigration Accountability Project and the Federation for American Immigration Reform. So, what's actually inside this bill? Buckle up, because it's a lot. It would completely halt new H-1B visa issuance for 3 full years before restarting the program under dramatically stricter rules. It would also make the controversial $100,000 fee per H-1B petition permanent, and here's an important detail worth knowing: that fee was originally introduced under the Trump administration, but it was recently struck down by a federal appeals court, which ruled it was an unauthorized tax since Congress had never actually approved it. So, essentially, this bill is an attempt to get Congress to legally lock that fee in for good this time. Beyond the pause and the fee, the bill would replace the random lottery entirely with a permanent wage-based selection process, meaning higher-paying job offers get prioritized over everyone else, and it would slash the annual cap all the way down to just 25,000 visas, while requiring a minimum salary of $200,000 for H-1B workers, a massive jump compared to current wage requirements. And it honestly doesn't stop there. The bill would ban concurrent H-1B employment and third-party staffing arrangements, end the dual intent rule that currently allows H-1B workers to pursue a green card while they're on the visa, and even eliminate H-4 visas for family members of H-1B holders, which means spouses and children could lose the ability to live, study, or even open a bank account in the U.S. alongside the primary visa holder. On top of all of that, it would bar federal agencies from sponsoring or employing non-immigrant visa holders altogether, and it would eliminate optional practical training work authorization for international students and certain exchange visitors if it ever becomes law nationwide. Now, before anyone panics, I want to be really clear about something important. This is only a proposed bill right now. It still has to pass both the Senate and the House of Representatives before it can become actual law, and at this stage, it's simply sitting in committee, so nothing here is final or guaranteed. But the fact that a sitting U.S. Senator is pushing something this aggressive tells you exactly where at least part of Congress wants to take H-1B policy next, and that alone is worth keeping an eye on. So let's recap everything that hit the immigration world this week, because it's genuinely a lot to take in. We've got major forward movement in the August visa bulletin for family-sponsored applicants. The H-1B cap for FY2027 officially closed under a brand-new wage-weighted selection system, a huge shift for international students losing duration of status starting September 15th, a restored 30-day deadline for asylum work permits, and a sweeping new Senate bill that could pause H-1B visas entirely for 3 years if it ever actually becomes law. These changes together could affect thousands of current and future applicants across literally every part of the U.S. immigration system, so please keep following trusted official sources and turn on notifications from verified government pages so nothing catches you off guard. And honestly, before you go, if this video helped you understand what's happening, do me a favor and hit that subscribe button, turn on notifications, and stick around, because we are going to be tracking every single twist in this story, including whether Sheehy's bill actually gains traction in Congress as it continues to develop in the weeks ahead. See you in the next one.